Swayam Prabha. Digital India. Educated India.
A very warm welcome in the first module of week 4 of the course Roadmap for Patent Creation titled IP Identification Tool. By this time you have received pretty well idea about what is patent, how to read a patent, what are the different terminologies, what are the parts of a patent, etc. We have also understood that IP identification is the challenge. We have shared with you an example of Genentech. You know what happened in this case. Here the inventor, a domain expert, worked hard and invented novel technology. But he could not understood the potential IP in his invention and published this invention. The IP potential is understood by the technology officer and he has taken efforts to file that patent. Now, to avoid such instances, we are giving you the IP identification tool. So, in this module, you will see what that IP identification tool is. You can directly apply this tool to your research or project already you are working on it, or if there are some ideas in your mind and if you are planning to proceed to explore that idea, then you can apply this tool. This tool is nothing but an algorithm which if you follow, it will help you in potential IP identification as well as better research planning. So, starting with an idea. You know the thinking mind, so many ideas pop up in your mind. It is not necessary that all the ideas which comes in your mind you consider for the project or you start working on it. You will take an example. Suppose you are, we will take that example, some examples. Suppose you are working on some project, you are a project staff or you are a student and working on the project or you are a researcher and you are working on some of your research topic. How you should proceed so that you can identify the IP in your work or you can consider it in other way, how you can plan your research so that at a particular time you think of filing the patent application. It may be a provisional patent or it may be a complete specification, whatever it may be. So, here the first thing is that the idea. Selection of idea from that pool of idea is the first task. Then the next task is that a prior art search. So, from the pool of ideas you have selected, okay, at this time I will work on this idea. So, the next step will be the prior art search. Now, you know what that prior art search is, what is the state of the art is, that terminology also you are aware about. So, it is your first duty or rather we can say that it is mandatory now that before proceeding any research related activity you will check the prior art. That is the part of a literature review, right. It is nothing but a deep in-depth literature review. So, here normally you follow a literature review where you just go through the research papers or a magazines whatever the published in the magazines, and that kind of publications you explore and try to understand what is the current scenario in your domain. But when now you are knowing about a patent, you should think about the patent also. So, you should go through the patent documents along with that research papers, magazines, newspapers, books, etc. In this way, you will do the prior art search, that is a primary requirement. Now, what is the advantage of that or what will be the benefit out of this activity? You will get the idea about what is currently going on in your technology domain, what the work is going on. Now, once you know that state of the art, then you can plan your research activity. Many times, you will experience that whatever you are thinking of exploring, through the patent search you realize that this work is already done. This may not be guessed by you may not able to identify that thing with a research paper analysis, but probably the patent will help you to get this realization that okay, already this work is done, patent is filed. So, if such kind of thing is there, you can refine the research topic and the objectives, and after going thoroughly, then you can thoroughly through the patent documents, you can plan your research activity further, or you can plan your project activity. So, that is a second step. The next is a research activity. So, from the idea you have selected that one idea, now you have done the prior art search, now you have started your research, the experiment. So, whatever procedures, methodology you have decided, you have followed that, right. Now, the next is a invention disclosure. Now, generally what happens that invention disclosure is a step in the research, and that is a very important step. You have to plan properly and you have to decide properly when you will give that invention disclosure. So, this is the point or a time during your research you feel that my research is going pretty well and it is well enough to file now the invention disclosure. So, that judgment you have to judge that thing and you have to file the invention disclosure. If you are a PhD student, or if you are a student doing a project, or you are working in a MSME, or you might be working in a R&D department of a corporate, or you may be a scientist working in a research laboratory, you have to review the timeline you have decided before starting the project. So, before planning that, before starting your research, you might have planned some activity, and at that time only you have to decide at what time you will file the patent, or probability of filing the patent is. So, probably you can plan this review that after 6 months to check if there is something which can be considered for patent filing. So, maybe in your research activity, after every 6 months you just review your activity, whatever research activity is there, and you just explore, is there possibility of filing a patent. That way you can just identify that if there is any potential patent. So, we follow this, and then we generally follow this when we are doing a research publication. Whenever you are confident, okay, now I can write a research paper, then you start research paper and communicate with the publisher. So, same thing you have to do with the patent. And again important that no publication without patent, because rule is first to file. We cannot predict any time, we cannot predict any timeline for what, at what time means how the patent will be, that invention disclosure will be filed. However, generally for a PhD, if you are doing a PhD or a research in that academic institute, this stage generally, that is a invention disclosure filing stage, generally comes in the 3rd year or a 4th year. So, whenever your research is mature, then at that time you can think of filing a invention disclosure. There may be a possibility, a different possibility in other setups. So, for example, if it is a MSME, or if you are doing a student the projects in a student projects in the engineering colleges or in a science colleges, or if you are a corporate, this stage may differ. It may come in 1 year also. So, good research planning will help you to anticipate this timeline, this patent filing step. Thus, it will be a director activity and chances of identification of potential patent will be more. So, this is the identification of a potential patent and then filing the invention disclosure. Now, after that you have to check the patentability, or you have to perform the novelty search. What is that novelty search? This we have already seen. Then what are the various patentability criteria, that also you know. So, now with this awareness you have to think about the you are also knowing what is a patent, what is patentability criteria. You can check out your invention whether it falls under the invention whatever given in the Patent Act. So, you will check if the invention can be considered further for patent filing. You yourself can do this patentability search. You will require patent database to check that novelty. There are free public patent databases. In upcoming module in this week only, we have dedicated one module on how to use a public databases, public patent databases. So, this will help you to dig out the patents and to check the patentability. Also in week 6, we are dealing with a patent database, use of patent database for a research project. In this week, one of the module we are sharing list of various patent databases which you can explore. By using these databases, you can dig out the related patents from the public databases and you can check the patentability. So, this way the patentability search can be done. Now, the next is a patent filing procedure. If IP management system in your organization where you are working is well established, then obviously you need not to worry about the patent filing. Please take help from that system. Officers there will help you in patent filing. You can understand invention disclosure procedure system from that officers and you can proceed for filing the invention disclosure form. That filing may be manual or it may be a digital filing. So, depending on the setup in your organization, you have to proceed for a invention disclosure. Mostly in considering the academic institutes, mostly in all the IITs, there is a established IP system and this system helps you in filing the patent. Now, if you are a MSME or if you are a student working in university and if there is no facility for an invention disclosure or if there is nobody to help you, in that case you have to take a help of a patent attorney. And then many times there is a question in your mind whether the secrecy directions will be maintained, whether my invention will not be stolen. You will worry if there will be any theft of my invention. All these kinds of fears always pops up in your mind. So, what is the solution for that in such scenario? One solution is that you ask for a non-disclosure agreement before disclosing your invention to a patent attorney or a patent agent who will deal with the invention disclosure and who is going to draft your patent. That is a one way. And but the thing is that generally there is no any issue of theft. However, if you have that fear in your mind, you can follow that NDA procedure and all that thing. The second thing what you can do is that if you are sure about stage of your research and if you are sure that okay, within next 12 months I am able to complete my research up to the level that I can write the complete specification. That is a complete details of my invention I will be able to complete in upcoming 12 months. If that surety is there, if that guarantee is there, that is a guarantee about the specifications. I am not talking about the prototype. Prototype you may not able to develop within that research time and all that thing, but if on paper if you are able to write that specifications related to your project and if you have that confidence that you will be able to complete your that related research by that time, the best and the easy way to avoid that fear is that you yourself can file a provisional patent specification. So, what that provisional and complete specification is? Briefly I will explain it here, what the provisional patent and a complete specification is. We will see in details of that in upcoming modules. So, provisional specification and a complete specification, these are the two stages of a patent application. In short, provisional specification is an initial broad write-up about your research. There are certain rules, but you can draft provisional patent by knowing that simple rules, you will able to draft that patent specification, that is a provisional patent specification. So, you have to do that write up and you have to fill certain forms and you have to submit that provisional patent application in the patent office. Now, this arrangement is necessary to secure the priority. It is the best arrangement to secure the priority and you know that first to file rule, right. So, this provisional patent you are able to draft it. There are some skills required for provisional patent specification drafting, but not that much whatever required for the drafting of a complete specification. So, what I can suggest here is that you yourself can go for a provisional patent drafting, that is a best way. For complete specification, you should take a patent attorney or a patent agent, because for a complete specification drafting, claim drafting, you require help of an expert, and there it is suggested that you should take help of a patent attorney, but for provisional you yourself can do that thing. Now, you are expert, you are not expert in a patent drafting. So, it is always suggested that a complete specification is done by the expert, that is a patent agent or a patent attorney. Probably that will be very safe way, this provisional patent filing will be the safe way for you to disclose your invention to anybody, including patent attorney, funding agency or all other agencies with whom you are planning a commercialization activity or any other collaborative activity or anything related to your patent. So, that is what is about the patent filing. Now, the next is a FTO search, that is a freedom to operate search. So, we have seen novelty or patentability search. For patentability search, it is a starting point of your what we can say research activity. Now, this FTO, it is almost a last stage in your research activity. Now, this freedom to operate search means it is a search which is done to check the status, you are checking once against the status in the market if anybody have not done the invention disclosure or if anybody is not having any patent related to your invention. So, I can put it in a way that when you are going to the market at that time you have to do a freedom to operate search. You can go to the market means after provisional patent filing you can start the commercialization and you can start commercialization, but the actual rights you are getting after the patent is granted, right. You can execute your rights after granting of the patent, but after provisional patent filing you can start the commercialization or any other activity you have planned. You can start the commercialization. It is always good practice to do a freedom to operate search, where you check whether there is no any patent in force and if I am not infringing the patent of other. Most of the corporates always do this freedom to operate search before launching of the product. Okay. So, this is about the freedom to operate search, because you should appreciate that within 1 month also there is a possibility that 18 months gap is there, then that within 1 month also there is a possibility that before you have filed a patent, somebody have filed the patent and that is published in that 1 month. So, that is necessary. The next is a invention commercialization. Once you are sure about a freedom to operate report and you are sure about there will not be any infringement issue, then you can start the commercialization activity. So, this is what the idea, that to the invention disclosure and then the commercialization. This is a general cycle. Now, after that what exactly is the other ways that the invention commercialization is that technology transfer. So, technology transfer may involve any of the activities or it may in the form of a joint venture, collaboration, licensing, selling, anything. That license may be exclusive license, non-exclusive license. So, after patent filing you can do all these activities related to commercialization. So, this is one cycle from idea to invention commercialization. Now, here is another way. The idea, then what procedures you follow in the laboratory, means the idea you are now exploring that idea, you are working on that ideas. So, here it is suggested that whenever you are doing that particular invention, you are working on that particular invention, the thing suggested is that, or the good practice is that you should maintain a lab notebook. Most of the organizations follow use of a lab notebook. In layman language, lab notebook is nothing but a book which is maintained in your lab. Maintaining the lab note means maintaining all the activities which are going on in the laboratory when you are exploring that particular idea or you are doing the research. Maintaining the lab notebook is always a good practice. You have to write a lab notebook almost every day. You have to write the progress of your research, whatever work you are doing, just mention it in the lab notebook. This is an important step or a procedure. Okay. Now, you can write the procedures you are following, what are the findings. If there is a positive result, you write down that. If there is a negative result, you write down. So, whatever the output of your research is there, you have to mention it in the lab notebook. Whatever ideas pops up in your mind, it is also good practice to write that ideas in your lab notebook. So, this way you are recording the everything whatever going on in the laboratory in that lab notebook. So, for example, after 1 year or 2 years, whenever you go back and you check the lab notebook, and you will obviously get how your research is progressed, and after going through that, many times what happen, you can visit that ideas or you can get a new way to do the things. So, this is generally observed when you are going through the lab notebook. Now, legal point of view, lab notebook is very useful because if there is any mess up, bad luck, and if your invention is copied by someone or used by someone without your permission, then lab notebook will be the proper evidence. We can say that lab notebook will help you to prove that you are the one who have worked on that project. So, it is always a good practice to maintain a lab notebook. There are rules and regulations how to maintain a lab notebook. So, we have dedicated one module on maintenance of a lab notebook. So, that is about the lab notebook. Then obviously, already we have seen the prior art search. Okay, so search already we have been briefly touched upon that prior art search. Now, after that prior art search, next is you have to check the patentability. You know, you have to check the invention is following that 3 criteria. If you are satisfied with that, then you can proceed for a patent filing. Okay. Now, the another way of managing research is that when you do a prior art search, you dig out literature which include research papers and patent. You know how to do a research paper analysis to identify research gap. Similarly, when you take out the patent, you can do the analysis of that patents also. One analysis you can do to check a technology in which you are working and find the gap in the domain. So, you do a technology mapping. The second is that you can check the bibliographic information. What is that bibliographic information in the patent? Who is assignee, who is inventor. So, this information will be very useful to you, as already we have mentioned in earlier module that in the technology transfer this assignee mapping helps. This assignee mapping as well as a technology mapping will help you in various things such as a collaborations or joint ventures or licensing, etc. So, technology mapping will help you to give the new ideas and you can check out the new opportunities. So, from the single starting point, by doing this technology mapping, you can bifurcate your research and you can just chop out the small ideas which are popped up or which you have identified because of the analysis of the patent, and you can start working on that small research projects, okay, within that big project. Now, after this, it will follow the same line, that is a invention disclosure, patentability search, patent filing, freedom to operate search, and then the invention commercialization. So, this is what in short the patentability, or this is what in short the IP identification tool is.
This is one in a series of videos about intellectual property and you. An IP strategy can assist your business with extracting value from your intangible assets, like the name of your product or services that you have in the market, inventions that you have developed, or your confidential business information. Your IP strategy is an important component of your overall business strategy. It's a plan in which you determine what IP assets give your business its competitive advantage and where and when you should protect them. Your IP strategy should identify how you will leverage your IP assets in order to grow your business and gain a competitive advantage. Will you bring your IP assets to the marketplace? Or will you be licensing or franchising your IP rights to a third party? Having a solid IP strategy will help you develop strong partnerships and seek financing if required. It should indicate the types of agreements and terms your organization will support. Remember, you should define an IP management process which includes monitoring the marketplace for possible violations of your IP rights. Do you have a plan to defend and enforce your rights? Finally, it's a good way to communicate to your management team and your employees the importance of IP, your short and long-term vision, and the strategies you plan on using to leverage your IP. For more information, you can contact the Canadian Intellectual Property Office or visit our website.
I suggest after watching this video, please spend some time and follow the tool. First, write down the ideas in your mind, then check the feasibility of executing any of the ideas, and then subsequently follow the steps which are mentioned in the tool. We can take an example. Suppose you are working in a mechanical engineering domain, or if you are a chemical engineer, then you can start with ideas related to your domain already you are working or you are thinking about that. Now, define the stages, identify the timeline for a invention disclosure, and then you do the patentability search yourself. Then based on that, refine the research topic, and then proceed for the research and then file the patent or provisional patent filing and all that thing. So, that whatever the provisional patent, complete specification depending on the resource available with you, and then before commercialization perform the FTO search. And this way you can follow from that idea to the commercialization cycle of the patent, and in this way this cycle will continue and you can manage your research. The other way, if ready with any, if you are already working and you are somewhere in the middle of a research, then by using this tool you can refine the your activities and you can just identify if there is any potential patent. So, what I will suggest that today only after going through this module, you just sit down and apply this to your research work. This will help you to identify potential patent, or at least you will start thinking in that direction. Okay. So, with this we come to the end of this session. In the next session, that is a patentability tool, we will check how to determine the patentability. See you in the next session. Thank you.